Dear friends, in this course on social welfare and social legislation, you have so far been introduced to the fundamentals of the Constitution of India as far as they are relevant to this particular course. We have looked at the broad outlines of the Constitution of India. We have looked at the Charter of Rights, the fundamental rights in the Constitution of India. We have also looked at the directive principles of state policy. Now, we have come to a stage where we have to see these principles, these rights in action in their dynamic state. While the most of the rest of this course is about looking at various governmental initiatives, various governmental policies and legislations, at this stage we would like to introduce you to the concept of judicial activism and public interest litigation. If you remember from the previous lecture, we had stated that one of the directive principles talks about the safeguarding of the independence of judiciary. What does that mean? What does that entail? It's very simple. In the Constitution of India, there is a particular setup. There is a setup of three different branches of government, broadly three different branches. There are other smaller branches, but we should look at these three branches to understand the point. These three branches are the executive, the judiciary and the legislature. These three branches of the government basically have in their totality all the power that the government has. But the point of having three branches is to ensure that no branch stands so much above the rest that it becomes without any accountability. It is important that all the branches are accountable to someone or the other, so that they don't become arbitrary, so that they don't become dictatorial. Of all these branches, the one which stands on a different footing and one which has relatively the largest autonomy is the judiciary. The judiciary of India is composed of a multitude of courts which are spread throughout the length and breadth of country. These courts, in their turn, are controlled by the respective state high courts. These high courts are constitutional courts. They have the power to make sure that the fundamental rights of people are saved and protected. They also have administrative powers over the various inferior courts. Above all these courts and having appellate power over the high courts is the Supreme Court of India, which has its seat at New Delhi. The Supreme Court of India is the highest decision making authority in judicial matters in India. The Supreme Court has very wide powers of issuing writs to ensure that the fundamental rights are not violated under Article 32 of the Constitution of India. The Supreme Court has certain other powers as well, which include making decisions in cases involving conflicts between the states and the centre, in matters involving conflicts between two states, in matters involving issues of water sharing and certain other matters. The Supreme Court is an institution which stands above most other institutions in a singular manner, which is this, that the Supreme Court is in most matters the final adjudicating authority. The decisions of the Supreme Court may not be challenged anywhere in any institution, and they have a finality. While the Supreme Court itself has a power to review its decisions, the decisions of the Supreme Court are not reviewable in any outside authority. This freedom of Supreme Court is maintained through various channels. First of all, after 1991 and further clarified in 1998, the appointment of judges to the Supreme Court is done almost entirely by the judiciary itself. Therefore, there is little or no control of the executive as far as the appointment of judges is concerned. The Supreme Court also is absolutely assured of continued use of government resources as far as it requires them, because its funds are released from the consolidated fund of India, and they are not to be voted again and again by the governments in power. Also, the salaries of the judges of the Supreme Court are similarly dispersed. Therefore, the Supreme Court is an institution which is not fettered by any other institution and has almost complete control over its own functioning, except those limitations which are constitutionally imposed upon it. Let us now look at the issue of judicial activism. You have been introduced to fundamental rights and directive principles of state policy. If you were not living in India, and if you believed that the written word reflects reality, you would be tempted to think that Indian society is completely egalitarian and steadily moving towards a more equal and just society. But you would be right if you thought it is not completely borne out by facts as we see them. The reason is that Indian society is growing towards the constitutional goals but has not arrived there yet. There is a constant striving towards the constitutional goals. It is the duty of the courts that the government keeps complying with the fundamental rights of the citizen. It is not only the courts which have to function, it is also the government which must comply with such requirements and strive towards the same. Courts are the protectors of the fundamental rights of citizens, while the actual active duty lies with the executive and the legislature. This duty of protection of fundamental rights has changed in its orientation over time. Earlier, the courts adhered strictly to the words of the Constitution, and only literal infractions of the fundamental rights were addressed. What do I mean by this statement? In earlier times, after the independence, the courts were very slow in asking the governments, in asking the executive, and in asking the legislatures to behave themselves. There were multiple reasons behind it. The courts were, before independence, functioning in a government wherein they had only so much control over the functioning of the executive and the legislative wings. The reason was that the government was run on an almost totalitarian basis, without there being any democratic accountability, and most importantly, there was no Constitution of India. There was no Charter of Rights. Therefore, the courts were hesitant in asking the governments to function in a certain way. Also, at the time of independence, the governments had enormous legitimacy. The governments had phenomenal public support, and also the governments were seen to be ushering into a time in which all the rights are protected and where people would be saved and helped in all times. However, as the time passed, it became clear that this was a utopian idea. The governments in India needed prodding, they needed to be controlled, and more importantly, they needed to be told when they were exceeding their rights. Let me give you an example from the initial times. In the beginning, unless the government infracted or broke any particular fundamental right as it was written, the courts were not enlarging the scope of the fundamental rights by interpreting them differently. Therefore, if the right to life states that life and liberty can be taken away only by procedure established by law, the courts will not look at whether that procedure is correct or not. Let me give an example which will make it clearer to you. If the government of India makes a law which states that anyone who has not followed a particular set of procedures in approaching the court will be punished with a fine of 20,000 rupees or with a jail term of 6 months. Now, if the government finds this to be the case, finds that procedures have not been complied with, and 6 months of jail term is given, the courts will not look into the fact whether the procedure established was right or wrong. All that the courts would look at was whether such a system which had been instituted has been followed or not. the appropriateness of that system per se would not be looked into. This approach means a literal interpretation approach. This was not an expansive approach. It was an approach which was in keeping with the limited role of judiciary. However, with the passage of time, it was realized that a more proactive approach by the courts was the need of the day. Arthur Schlesinger Jr. introduced the term judicial activism in a January 1947 Fortune magazine article titled The Supreme Court 1947. And I am quoting, Schlesinger's article profiled all 9 Supreme Court justices on the court, and we are talking about the US Supreme Court obviously, at that time, and explained the alliances and divisions amongst them. The article characterized Justices Black, Douglas, Murphy and Rutledge as the judicial activists. This is the first time this term is being used. And Justices Frankfurter, Jackson and Burton as the champions of self-restraint. Thus you can see that in this article, judicial activism is being seen as the counter of self-restraint. Justice Reed and Chief Justice Vinson comprised a middle group. We see a slight bend towards non-textual decision making amongst judges who believed in judicial activism. Black's Law Dictionary defines judicial activism as a philosophy of judicial decision making whereby judges allow their personal views about public policy, and please mark it, where judges allow their personal views about public policy amongst other factors to guide their decisions. David Strauss has argued that judicial activism can be narrowly defined as one or more of the 3 possible actions: overturning laws and unconstitutional, second, overturning judicial precedent, third, ruling against a preferred interpretation of the Constitution. Now let us take a few examples of judicial activism from American courts. First is Brown versus Board of Education. In this 1951 Supreme Court ruling, it was ordered that desegregation of public schools be done. In the case of Roe versus Wade, the 1973 ruling, in this particular case, abortion was decriminalized. In the case of Bush versus Gore, which is a very recent case, in this landmark United States Supreme Court case between the major party candidates in the 2000 election for President of United States, George W. Bush and Al Gore, the judges, voted along ideological lines in a 5-4 decision to halt the recount of ballots in Florida and in effect electing Bush as president. Now, the term judicial activism, as you can see, is used in a wide range of circumstances. Activism denotes the circumstances where a body or authority engages in purposeful and determined activity to achieve desired objects. In this process, that body or authority takes the side of a policy or objective. Analyzed from this angle, judicial activism means the process of judiciary taking sides of on some controversial issue or social policy. I will give you a particularly interesting example of this. Very recently, Justice Sudarshan Reddy of the Supreme Court of India declared the recruitment of police officers in Chhattisgarh, SPOs, Special Police Officers in Chhattisgarh, as illegal. As you can see, this recruitment was done by the government of Chhattisgarh, and this was found to be inappropriate as thought by Justice Sudarshan Reddy. This issue has been questioned in various fora. It has been questioned whether he had the expertise to pass such a judgment. But you must remember that no judgment of the Supreme Court can be questioned anywhere. And more importantly, there is an equally large body of thinkers who think that the judgment was valid in law and is completely right. We are no one to question the wisdom of the Supreme Court. But what is sought to be expressed here is the fact that the Supreme Court has often to deal with issues wherein the decision ultimately taken by the judge might seem to be a personal opinion. And when that has happened, one has to look at the issue of judicial activism coming in there. You must understand that judicial activism, as we are talking about in the current lecture, is a value neutral term. We are not seeking to pass a judgment on the correctness or inappropriateness of judicial activism, We are merely trying to look at judicial activism as one of the means of social welfare, as this course deals with social welfare and legislation. Another view taken is that there cannot be any judicial activism. The judiciary has always remained active, and in no instance can it afford to remain passive. It is, after all, the watchdog to ensure that the fundamental rights and other judicial rights, other constitutional rights, are complied with. Judicial activism is inherent in judicial review itself. It is not an aberration, but is a normal phenomena, and judicial review is bound to mature into judicial activism. After having extensively discussed judicial review, let us now move into trying to understand how this judicial activism is seen in action. We will obviously be looking at public interest litigation. A public interest litigation is a different sort of litigation. In normal litigation, there are defined parties whose legal rights have been affected. In public interest litigation, on the other hand, the person preferring the petition or the person making the application need not necessarily be hurt themselves. They might be bringing to the notice of the court any infraction of any wrong being committed against anyone and anything which relates to the welfare of public at large. This to effect this particular type of litigation, the Supreme Court of India has relaxed the requirements of locus. Thus, to file a public interest litigation, you need not always be directly affected. You might file an application on behalf of others. As a matter of fact, in certain cases, the Supreme Court has treated postcards as petitions in themselves. Thus, this is the dynamic facet of the judiciary acting to actively intervene and making sure that people's rights are not infracted. The public interest litigation as a movement, as a system of justice delivery, started in the late 70s and 80s. It has since matured into a specialized branch. It has been extensively used to correct many situations which needed active interventions. A few examples are the freeing of bonded labourers through the Bandhua Mukti Morcha case. Another example is to remove polluting buses from the streets of the National Capital Territory. There are multiple examples of public interest litigations. However, it has also been seen that public interest litigations are often used as instruments of personal gain. For instance, some of the judges have pointed to the fact that public interest litigations are often excessively used to hurt the interests of certain parties. They have called them personal interest litigations, when in the garb of the benefit of public, actually the interests of a few are being served. In a recent judgment, Balwant Singh Chaufal, the Chief Justice of India, has ruled that any frivolous public interest litigations would be dealt with severely by the court, because public interest litigation is a special method of justice delivery and it should not be allowed to be misused. The public interest litigations have been used in a wide variety of concerns, including environmental concerns, concerns relating to individual freedom, concerns relating to any particular activity, concerns relating to anything which affects public institutions. Thus, we find that public interest litigations are the dynamic aspect of judicial activism. They are the instruments through which judicial activism is actualized, through which judicial activism is actually brought into action. We have now seen through this lecture how judicial activism is the active, the dynamic aspect of judicial activity, how judicial activism brings judiciary to the fore and it leads the other branches of the government to what the constitutional rights dictate. We have also looked how some believe that judicial activism is an inherent aspect of judicial review and there is nothing new about it. We also know that India has one of the most free and one of the most active judicial wings in the world, and we also know that it has often intervened and corrected some grave injustices. After this understanding of judicial activism and a brief understanding of the public interest litigation, which is an instrument of enacting and enforcing various requisite steps which need to be taken, we are now ready to enter into the core areas of this particular paper on social welfare and social legislation. We are now going to see how various steps are taken and what are the needs which need to be addressed so that social welfare as it is envisioned in the Constitution is achieved and the directive principles of state policy are implemented, and it is made sure that all Indian citizens get what they need to lead a meaningful and fulfilling life.